Welcome back, and if you're just joining us, you're on the Polity, reaching you live from the nation's capital in Abuja. And with joining me now is Mabib Gaju to my left, a public analyst, and to my right is Barrister Emmanuel Mense Madaki, a legal practitioner. Welcome to the studio, sirs, gentlemen.
Thank you. Thank you. Thank you for having us.
Okay, all right. Let's get into business straight. And I'll be starting with one of the papers this morning that said Atiku will be open up on tribunal's verdict. Of course, they will be analyzing most of the recent happenings and the polity over the weekend. For today, our phone lines are going to be on, of course, for you to make any your contributions. But please remember to turn down the volume of your TV set, or you step away from your TV set for you to join in on the conversation this afternoon. I'll start with Atiku Obi open up on tribunal's verdict. Gentlemen, Obi has outrightly come out to say is refuting what the court has said and is heading to the Supreme Court, and likewise Atiku Abubakar of PDP. What do you think this means for both parties? I'll start with Mabib Gaju first.
Yeah, it's good for democracy.
Okay.
And it's a healthy democracy when you are not satisfied, you approach the higher court.
Okay.
Is normal in politics, in constitutional democracy.
Okay.
That's how it operates.
Okay.
Though I have my reservation with the judges.
Okay.
We have Nigerians have issues with the judgment.
Okay.
And Nigerians are saying justice has not been delivered because there is a lot of flaws in the
judgment.
Judgment.
Okay.
You know, striking out all evidences, I think is not justice.
Okay.
And also the FCT status, 5 judges cannot upturn the democracy or or upturn the constitution.
Okay.
Or change the constitution in 13 hours. I think we need more interpretation in Supreme Court.
Okay, all right.
Nigerians need to know.
Well, just like he has said, in a constitutional democracy, almost always you see that we have the hierarchy of courts.
Okay.
And for election petition tribunal, especially that of the president, it starts at the Court of Appeal.
Okay.
And by the hierarchy of courts that we have as enshrined under Section 6 of Section 6 of the Constitution, down there you see the way the courts have been enumerated. You know, at the lowest level, let's say you have some jurisdictions, you have customary courts, you have area courts, you have the High Court, and of course customary Court of Appeal, Sharia Court of Appeal, and then of course you have from the High Courts you go to the Court of Appeal, then the Supreme Court. For election petition tribunals, you discover that the presidential election starts at the Court of Appeal, and from the Court of Appeal it gets to the Supreme Court. And of course the Supreme Court is the last court based on the hierarchy of courts that we have. And then whatever the justices of the Supreme Court say is final in the real sense of finality, in that you cannot refute that judgment except and unless and until the Supreme Court sits again in another matter differently to overrule itself. Then the decision of the Supreme Court is final. So for Obi and Atiku to exercise their constitutional rights, because of course after the final decision of the Court of Appeal, as a candidate or as a party, you have the right of appeal. Because there are 2 types of appeals that we have: appeal as of right and appeal as of leave. But this time around, it is appeal as of right. This Court of Appeal, having finished its own job, now functus officio, it is now the duty of the Supreme Court now to assume jurisdiction over the matter, when the Supreme Court will now become the dominus litis in the matter.
Okay, all right. I like the fact that you've analyzed that, and since we have a legal practitioner in the house, can you make people understand, our viewers, I'm sure they're interested in one of what Nigerian Tribune said, and it's part of what the judges have said equally. You guys call them your lordship. One of your lordship has said FCT has no special votes, and remember there were lots of back and forth about 25% votes in FCT, because there was a clause that said and FCT back then. Can you please expatiate on that?
Well, you see, that provision, I think, is section 138 or 34 of the 1999 Constitution as amended, that says that a candidate should get to third of the total number of votes at least in 2/3 of the total number of states,
yeah.
and the FCT. Now, in a normal parlance, and means conjunctive, but some people will tell you and is disjunctive and is, but of course there are different rules of interpretation. We have the literal rule. If a word is as plain as a paper, you give it its ordinary meaning. And means, you know, Sarah and John. Okay, assuming a teacher wants to see he wants to see two students in the class. He said, I want to see Sarah and John. The interpretation is he wants to see the two students in his classroom. But then some people will tell you in law that we have 36 states. Now, giving FCT a special status would therefore means we have 37 states. And so, the 25% of the total number of votes which are needed in order to declare somebody a winner, some people will tell you, you only need it in 25 states. Once you are able to get 25% in 25 states, there is no need for you to get 25% in the FCT. But then, for me as a person, my sentiment, it therefore means if you say that FCT should also, you must get 25% in the FCT, it therefore means that FCT is given a special status, which of course the tribunal has come to say no. But then, in that same constitution, there's a portion that says that FCT shall be treated as if it was a state. That is to say, the privileges that a state should get, FCT should get. And that is why we have the FCT minister who presides over this FCT as the governor of the FCT, because all land instruments and everything are signed on behalf of the state by the FCT minister.
He is not a governor of FCT.
Yeah, that's why I say it is he's treated as if he is a governor.
No, he's a glorified commissioner. No, let us now that the appeal court, the tribunal, open up this, then we will talk. You understand? It's just a glorious commissioner appointed by the president.
Yes.
The president is the governor general of FCT. You understand?
So the governor appointed the commissioner.
Yes, but because the president cannot oversee Nigeria
and
FCT. The same, that's section 184 to section 138 gave the president power to nominate who will oversee on his behalf. So the military government now appoint somebody, they now call him as a minister. You understand?
Yes.
So he's just administering on behalf of the president.
Yes.
His mandate secretaries are approved by the president. They are special advisors of the president. If you check the number of appointees of the president, last week 8 of them were approved by were appointed by the president. You understand? Secondly, FCT don't have state assembly. It's National Assembly, House of Representatives, legislate for them. We call it bylaws. You understand? And if you come back to the president himself, the issue in contention is how can a governor general who will sit and preside in Abuja, as the constitution says, should be treated as a state. You understand? Now, and he did not win that state and will govern that state. It's unconstitutional. That's where the problem is. That's where the lacuna is. That's where Nigerians need a clarification. You understand? So all these things put together, the tribunal, the presidential tribunal has not done well. Let's call a spade a spade. You understand? It's time we ask questions so that we will have answers.
Okay, I like the fact that you have clearly stated that you don't think the tribunal has done well. Now, over to you. Do you think the tribunal did the right thing on Wednesday?
Well, as a lawyer, there is a principle of law that says the decision of a court, no matter how stupid and useless it is, it remains binding, valid, and subsisting until that decision is set aside. upturn an appeal.
Yeah.
So that is what we have as a decision of the court. That is what has been decided by the learned justices of the Court of Appeal. As individuals, the only way we can have that decision reviewed is when that decision is appealed against. And just like I've always told people, the justices are human beings. They think, they fall sick, they are also bereaved, and also most times they pass through emotional stress and trauma themselves. They are not gods, and they can never be equated to a god. So the way you would have made a mistake in deciding your family affair among your children, that is the same way that justices can also make mistakes, assuming there was a mistake in the decision. And that mistake can only be reviewed on appeal by the superior justices of the Supreme Court, who will now look at it and say this decision was wrong or it was right. That can only be ignited by filing the notice of appeal at the Supreme Court, and the Supreme Court sitting over that decision to say this was right or that was wrong.
That was wrong, okay.
But as it stands now, for me as a person, I will look at that decision as a lawyer. I will definitely, if I am to go to that decision, I will definitely come up with grounds of appeal. Why? Because, for instance, in the petition filed by Peter Obi, the Court of Appeal justices came to a conclusion that some of the witnesses whose witness statements were not front-loaded along with the petition. One thing we must understand is the fact that election petition in itself is sui generis. Sui generis in the sense that it is time sensitive. 14 days. The stakes are always high, always high, and almost always when those decisions or when those petitions come before the court, they are treated with serious attention and time sensitive nature of the petition. Now, those witnesses, their depositions were not accompanied along with the petition. The Electoral Act says, upon declaration of a person who has won, the respondent, the petitioner, shall have 21 days within which to file his petition. And if you go to this first schedule to the Electoral Act, it tells you that upon filing or at the point of filing the petition, the petitioner shall file the same petition along with the witness deposition on oath of the witnesses. And then the witness shall not be given an opportunity for oral evidence. That is to say, anything outside the 21 days is a nullity given by the tribunal. The petitioner shall have a right to file a reply upon the reply of the respondent. And having filed his own reply, he shall only restrict himself to answering issues that have been raised by the respondent that are not contained in his petition. And it is not an opportunity for the petitioner to rehash or add or subtract or do anything that will serve as if the petitioner is amending the petition. That is to tell you that the Electoral Act itself is a problem for the petitioner. Why? Because the time is limited, the time is very short, and so how do you expect somebody to gather witnesses in 18,000 polling units, file their witness deposition along with the petition? One. Two, election was conducted across the country, 36 states, including the FCT, and you are expected to file your petition to do a very thorough job within 21 days. The same thing with the respondent, and like it is always said, he who alleges must prove. The petitioner has the burden to prove his petition for him to be entitled to judgment, since he's seeking for a declaratory relief. The respondent, even if he does not call any witness, that is a law. Even if he does not come to say all the allegations are right or not, it is the duty of the petitioner to prove his petition. So what we saw, or that the tribunal did, striking out the depositions of those witnesses, was actually an infraction, because I know as a lawyer that there is a decision of the same Court of Appeal. I think a petition, senatorial election petition of Bayelsa State, Yenegua, that came to the Court of Appeal. Honorable Justice Abiru was the one that read the lead judgment. In that judgment, in fact, it's almost a scenario where the petitioner subpoenaed a witness to come and testify, and then the respondent filed an objection and said, no, this witness statement was not accompanied with the petition. But then the subpoena itself is a command, is an order of the judge. Since it's an order, it therefore means if you disobey that order, you can even be taken to prison for contempt of court. So now what we have is the same scenario. This witness, the position of the witnesses filed by Peter Obi, did not, of course, accompany the petition, but they were summoned upon a subpoena served on them, which of course they came and testified.
Okay.
At that point, if it was a subpoena duces tecum, that is to come and tender document alone, fine and good. But then if it was a subpoena ad testificandum, that is for the witness to come and testify in court, it does not stop the witness from coming to testify, even if he does not file his witness deposition on oath. There is a decision of the Court of Appeal delivered 2023 in July this year. The Court of Appeal said, go back, the judge, the tribunal chairman should make sure that that witness that was refused to testify should come and testify. It was an interlocutory appeal. But then, the Court of Appeal is an intermediate court. It is not the final court. And why it happened that way, or it became the final decision, is because for elections or tribunal of the State Assembly and the National Assembly, the final court is the Court of Appeal. They don't go to the Supreme Court. And that is why that decision became final. But since this one is going to the Supreme Court, but then we also have decisions of the Supreme Court that have come to say, and the Court of Appeal as well, that where a witness deposition of a supreme witness is not accompanied with a petition, that witness deposition cannot. Now we should await the Supreme Court to give us a final and clearer perspective to this, which of course may help us to enlarge and also fortify our electoral jurisprudence.
Okay, all right. Speaking about electoral jurisprudence, you wanted to add something? Okay, please go ahead.
You see, what happened in Osun State is the same way those political parties filed their petitions and their witnesses in Osun State, but the High Court, the
Court of Appeal,
tribunal, the lower tribunal, struck out all the witnesses and declared the former Osun State governor winner, Oyetola. When he appealed to the Supreme Court, to appeal court, the same witnesses were accepted at the Court of Appeal, and Demola Adeleke was declared. Go and check, barrister. Go and check Ademola Adeleke's.
I've read that case very well. In fact, I've applied that case in one of the petitions I'm handling in Plateau State.
Yes, very good. If you compare it with this presidential, you see it's almost the same thing how the lower court and gave the judgment. So you see, why Nigerians are not happy with the judgment is very clear that you can't strike out all the evidences. You have to accept some are true. INEC has not proven anything, but the court defended INEC. You understand? Is INEC that's supposed to come and defend the election it conducted.
I like the fact that you brought us to INEC now.
You understand?
Okay.
Now, the court is saying that it's not binding on INEC to
call witness, to call evidence.
To call evidence. They can't be forced to electronically transmit election
and electronically. You understand?
Actually, the second part of the 22
when you go back to the Electoral Act, the guideline of the INEC
conduct of election,
the conduct of election is a law. You understand? And this man choose electronic voting and transmission.
But then he didn't specify where he was going to transmit it. I think that's where the problem started from.
He said he's going to.
He never stated it was IREF. He wasn't stated there.
Yes,
it wasn't stated. It wasn't
stated. Now, whether stated or not stated, the law is very clear. It's the National Assembly that amend the Electoral Act, and is the chairman of INEC that, or the INEC produce the guideline of the election. And the guideline of election is the main subject in election cases. You understand?
Yes.
INEC's guideline and the Electoral Act combined together, INEC will defend their own election. The petitioner will now accuse where he he sees that he will accuse and the defendant will also defend, and INEC is one of the defendants, and INEC did not defend its election. That's where we are not comfortable with. You understand? Nigerians are not comfortable with that, and INEC need to come out, because the reason why I'm saying that, the INEC chairman, if you will recall, he has been saying that he is going to conduct election and electronic transmission, bimodal voting and
bimodal accreditation system.
Yes, and electronic transmission from World Coalition,
from the polling unit,
yes, to, you understand,
the IRF portal,
to IRF portal. You understand? He have said it more than 80 something times. Festus Okoye said it 98 times. They even went to Chatham House. They went and tested it. The journalists, he had a press conference. The journalists asked him, what of if there is a technical hitches? He said it will not even arise, because they have perfected everything. This is the best technology to use in election. Best technology, backup with batteries and so on, is to just transmit direct to the server, that all Nigerians will see it, and you understand. That's how he put it at that time. That's how he expressed how he's going to conduct the election. He tested it in some state, including FCT. We tested it in area 10. He went to Kenya and tested it again. He came back. He said it will not fail. And all of the sudden, he was telling us it has been hacked.
And it is pertinent to know that it's just a presidential result.
Let the court ask him. Yes, now let him defend how it has been hacked. You understand? This is technology. Technology is scientific. You understand?
The greatest challenge we have is us understanding the electoral jurisprudence, knowing fully that we are regulated by laws, and just like I stated earlier, the Electoral Act is the extant law that regulates the conduct of elections in Nigeria. The Electoral Act 2022 is the present law that monitored or governed the conduct of this election that we're talking about. And if you check, there are decisions, plethora, litany of decisions of the Supreme Court and even the Court of Appeal that have said that the guideline for the conduct of election is not a law. It's not an integral part of the Electoral Act. Why? Because the Electoral Act is what the President Muhammadu Buhari assented to become a law. The guideline is churned out by INEC. It is the manual and guidelines for the conduct of election for electoral officers. That is to say, this guideline is what should guide the electoral officers who have been taken to the field and who are expected to conduct the election. That is to say,
where did the INEC chairman drive his power to come out with this? Come with the guideline.
Now that is the issue.
It's the law.
Now the law empowers the INEC chairman go and bring guidelines that will govern the conduct of this election. But then
you should have committed.
Exactly. Now what I would have expected the National Assembly to do is to look at this. If at all we are honest with the issue of electronic transmission of result, or the invitation of technology into our electoral process, we should inculcate this in our Electoral Act, so that by the time that you fail to comply with the provision of the Electoral Act, you know it will be counted against you. But this time around, you are leaving it at the whims and caprices of the electoral chairman to say, okay, fine, transmit it electronically, or there's going to be transfer of result. The Court of Appeal in this decision interpreted the issue of transfer of the election result to the final collation center. That is to say, from the polling unit to the World Collation Center, local government collation center, the state collation center, to the final collation center. And these are the various, for us to actually forestall the discrepancies and variations in our interpretation of this. Let this be straightforward. Let this be inculcated into the Electoral Act. And for me, I'm even advocating a situation whereby to curtail this issue of 180 days before the conduct of election. Conduct election 1 year to the final expiration of the person's tenure. Let us ventilate our grievances within that period up to the Supreme Court. Give the petitioner maximum time to prepare for his petition. Give the respondent maximum time to prepare his defense, so that at the end of the day, Nigerians and the whole world will know nobody was rushed into just filing anything. He was given adequate time to prepare for his petition. He was given adequate time to defend his petition, and the courts also, where the judges were also given adequate time to sit, read the papers, and also dispense justice.
Okay, right. Before we get into the next question, gentlemen, I'd like to take us back to a press release made by the Independent National Electoral Commission. I just sent it to our MCR guys. I do hope they display it on the screen. I'd like to read it word for word. Let's plot to abandon the transmission of polling unit results to IREF portal. That was when there was lots of rumors then that INEC won't have. They were looking for ways not to transmit the results in real time. And then INEC, of course, came out to say attention has been drawn to report in a section of the media of alleged plans by the Commission to rig the 2023 general election by abandoning the direct and real-time electronic upload of polling unit results to the INEC result viewing, that's IREF portal, by the registration area of technical support staff. Now, the claim is patently false. That's coming from INEC. The Commission has repeatedly reassured Nigerians that it will transmit results directly from the polling units, as we witnessed in Ekiti and Osun State governorship elections, and 103 more constituencies where off-cycle election FCT area council, where the IREF is one of the innovations introduced by the Commission to ensure the integrity and credibility of election results in Nigeria. It is therefore inconceivable that the Commission will turn around and undermine its own innovation. What happened between then and now? I'm trying to find the date here, but then there's no date attached to this. Between August 2020 and February 2023, what happened?
Exactly.
You see, the Commission has already rubbish itself. They have lacked the credibility, they lack the integrity that they are mentioning in their own statement. You understand? You can't promise A and you go and do X. You understand? Like I said, you see, during the public hearing of in National Assembly, ad hoc committee on during the electoral amendment bill, the INEC chairman was asked, his commission was asked, which type of election will you conduct in 2023? He said, we are going to conduct electronic. They asked him again, what of if that election, the electronic fails? He said it won't fail, like they have mentioned in off-season elections. You understand? Including FCT.
Even going to shut our mouths too, of course.
You understand? To defend the electronic system. He even said technology has come to stay in INEC, in the Commission. You understand? So we believe them. Nigerians believe them. Before, Nigerians don't believe in INEC. Nobody, some tear their voter card, some burnt it, some scatter it, some they stop participating in any election again. You understand? But he gave Nigerians confidence. And let me tell you, Barrister,
yes, sir,
you have mentioned enough time given by not given by the political parties and the candidate and the tribunal. Do you know how much time was given to INEC? 4 good years to conduct this election. Yes. Do you know how much money was pumped into INEC to make sure they have conducted a free, fair, credible, and acceptable acceptable election by the president and the chairman of the commission. The commander-in-chief, then General Muhammadu Buhari, that's what he told the whole world. Even in United Nations General Assembly, he said
the legacy is going to leave
if
the free election.
And they conducted this kind of sham election because it's a sham. Everything has not worked the way it has been planned or the way it has been promised. You know, as a politicians will be angry. You understand? People, Nigerians, will be angry that we have taken aback and so on, while we have made gains. I remember during Abel Gubadia, we know what happened. It was a paper, we queue up, you vote, you give another person your card, you will go and vote. This one, you understand? Multiple and thumb printing and so on. During Morris, ballot box snatchings, violence and so on. During Jiga, it was card reader. During machine. During Mahmoud is Vivas. You understand? We have come a long way. Mahmoud should have consolidated all these things and we move so that our election will be credible,
right,
so that it will be acceptable.
All right, please, can we quickly take this call? I'm sure it's one of our callers. Hello, good afternoon.
Yeah, beautiful Friday afternoon, you Babajide. Barrister, good afternoon. Honorable Gajo, good afternoon. You are on to SMD from Lagos.
All right, SMD, thank you for calling. Please join in on the conversation in 60 seconds.
Thank you very much, Gajo. Thank you very much. You see, let me put it this way: the INEC issue and the Arab saga.
Okay.
Babajide, Barrister, we all know that big money has been spent into that project.
Okay.
And that is the taxpayer money, Nigerian money. And then in the process of doing that, I could remember there is a trial of that Arif on the Vivas and so on and so forth, going on and on and on. And INEC come out and said, yeah, it's okay, they are good to go. Because everything is okay, there are some issues, but that can be handled. And when they were doing that, they never make a provision of improvisation in case of these technical faults or something of that nature. What do we do? So the Nigerians know right from day one that in the absence of Mr. A, Mr. B can work for us. They didn't do that. We are talking about the financial status that have gone far into that technology, which everybody was happy that now we are in an advanced system, so all these matching ballots and so on and so forth will not happen. But look at where we are today. So the question is, that is why I said, there is need for these other opposition parties to lead up to the Supreme Court, because there are so many things that require legal interpretation. And the only way to get that is to the Supreme Court, not even Court of Appeal, because so many things. If the court will say INEC is an independent body and they have all the right to do whatever they want to do, fine. Why are they doing? Why are not doing so many things in the system? So many things. For example, they have voters education unit. This voters education unit is not working until 4 years, and we are still paying salary with our taxpayer money. They are paying them salary. Why not, as an independent body, to allow that particular department to relax until when it is election, so that we know they are temporary workers? If there is this voter education, we even need so many things will not go wrong. Where is the independency? That's number one. Secondly, if you are making a project, you must have to have an option. In case this will fail, then we go for this. We haven't seen that. That is why I said there is need for legal interpretation, and the only way to get that is to the Supreme Court. And we can't just keep on. No, in those days we are into option A4. Are we still expecting to go back into option A4 at this 21st century? Are we expecting that? After when the world is advancing, the world is into AI, artificial intelligence, and so on and so forth, and we're expecting Nigeria 63 of independence, 24 years of interrupted democracy, and then we want to go back to option A4? Is that what we want? After all, we have the financial resources. Why can't we do the same? That's the question. So please, I advise the opposition parties to lift this issue up to the Supreme Court so that we have that legal interpretation for betterment of at least a layman like me. Because all these law issue is a technical issue, and believe me, sometimes the technicalities complicate easy matters.
Yes, that's
so let them go so that we have the clear issue of exactly what is on ground. Thank you very much. I remain from Lagos.
All right, thank you so much, SMD, for joining in the conversation.
So, like I'm saying before the caller called,
Okay.
even he called at the right time. You understand?
Yes.
You see, let me give you example of what happened in United States of America in 2020 election of Joe Biden and Trump. Their voting system is electronic.
Okay.
The result is electronic. Trump accused the election is being systematically rigged. In a few days, they did a recounting, manual recounting. So when you adopt electronic voting, you understand? Like these petitions, these political parties, PDP, Labour Party, and APM that went to court, all what they need is recounting. Appeal court should have allowed a recounting of vote, rather went on technicalities to dismantle all the evidences. You understand? One, I will still come back to the FCT issue. During Obasanjo, I think it's during Abel Gubadia, Dr. Abel Gubadia as a chairman of the commission.
Yeah.
Obasanjo did not got 25% of FCT. Ereti Kingibe, then as a senator, got 25%. In 2023, Senator Ereti Kingibe contested with Issa Mena. Issa Mena of PDP and Obasanjo and Philip Aduda of House of Rep did not got 25% at that time. But because of the law, the constitution that says 25%, Abel Gubadia now announced the fix on Thursday to rerun FCT. And we rerun FCT. That's how Ereti Kingibe lost, Issa Mena won, Obasanjo won, Philip Aduda won as House of Rep. That's how Ereti Kingibe lost. That's how the AMPP candidate lost. You understand? I forgot the name of the AMPP candidate of House of Rep. You see, so we already have a precedent. But this INEC chairman did not wait, did not follow the law. He went ahead without checking, without all warning that 25% of FCT, he went ahead and declared the election. Had it been he have rerun FCT, all this matter will have not arisen. You understand?
So you believe that there should have been a rerun in FCT again?
Yes, before the announcement of the winner of the presidential election.
Why should there have been a rerun? Because
it happened before. It's a law. It's the constitution that says you must have. You understand?
Well, just like I've said earlier on, you see, that provision of the law has been subjected to series of interpretations. I think it was during Shagari's time that this issue was presented before the Supreme Court. I think the 1979 Constitution then, which of course the provisions are almost on all fours with the same provisions that we have today.
Of 1999
Constitution.
So now the 1979 supplanted same into 1999 Constitution, which we have today. I think the Supreme Court that time said that the words may have been inelegantly couched, but they are semantically correct.
What does that mean?
Which means that
time?
Yes, which means to say 2/3 of the total number of votes in the 2/3 number of states and the FCT. Meaning that FCT is also included in the total number of states, that one should get the 25%. This time around, the Court of Appeal is saying no. The 25%, there is nowhere where FCT has been given any preferential treatment or special status different from any other states. And moving forward, in that provision of the Constitution, it is being said that FCT shall be treated as if it was one of the states. Now, if FCT should be treated as one of the states, and somebody is now trying to tell you, bringing FCT into the 36 states, that means we now have 37 states. Meaning, if you have 25% in any of the 25 states, forget about FCT. But I know it is on record that from 1999 till date, till the last President Muhammadu Buhari's tenure, nobody was ever declared as a winner without getting 25% in the FCT. This will be the first time in the history of the return of democracy since 1999 that a president will be declared a winner, but that president or that person has not scored 25% in the FCT. But like I've said, the Court of Appeal has decided. You have already hit the mark.
Let's move away from that.
Like I've said, let me just chip in this. Okay. Like I've said, the Supreme Court has decided. Now let's await what the Court of Appeal has decided. Let's await what the Supreme Court will say on this, and that will now be the last straw that will break the camel's back.
Okay, still speaking about court issues, I'd like to take us to one of the parties in Nigeria, that's Labour Party, where there's been lots of back and forth in court. Well, as of August 24th in Imo State, one of the courts declared the Apapa faction of the Labour Party the sitting chairman of Labour Party. And then, apart from that, this same faction endorses the verdict. I mean, they endorsed the verdict that happened on Wednesday, saying, oh, they are fine with it. And then, of course, we know that Peter Obi has said there's going to be, they are going to move forward in looking for democracy and, of course, move to the Supreme Court. How does this affect Labour Party generally? Because, of course, I don't think the party should be able to take any action without the involvement of the party. And since there is a existing law that states that the Apapa faction, which of course is not in sync with Peter Obi's faction, how is this going to be a major effect? Is there going to be a ripple effect from this moving forward?
I do not think there would be any effect, because Section 36 of the Constitution says no law shall be applied retrospectively. Okay. As at the time when Peter Obi contested, who was the chairman?
It was Abure.
Now, the chairman as at that time is the person to be reckoned with. Anything that happened after the election, all their post-election cases and all of that, that will only help to shaping the party against future elections. And know what has happened already. And that takes us to understanding the fact that in a constitutional democracy, just like I've said, we are governed by laws. What we have today are the issues that happened during the conduct of the election. In fact, the law is always settled that anything that did not happen contemporaneously with the conduct of the election is not even a subject for the election tribunal to determine. And that is why the issue, for instance, the issue of Kashim Shettima, the issue of Tinubu not qualified, the other person not qualified, have been termed as pre-election matter. And that is why the Electoral Act has given the Federal High Court the jurisdiction to hear any dispute in respect of the candidates, how he is, because the election tribunal has been specially crafted and actually crafted to entertain issues that happen at or during the conduct of the election. Okay. For instance, the issue of Peter Obi, whether what is before the court is whether Peter Obi of the Labour Party won the election or not. That is what the tribunal has to determine. The issue of whether Abure or Apapa or whoever the person is the chairman or not the chairman, that is an internal affair of the party that the tribunal does not even have jurisdiction to entertain. So internal wrangling of a party cannot even give another party jurisdiction to even go to court and say, look, since this party is having issue, declare their candidates as not competent enough to even have stood or contested the election in the first place.
Okay. All right. Before you, I would like to ask one more question with that last question. Some people have said Apapa is a Confucianist. I mean, he was sent to the party to confusion them. What's your take on that? Plus the last question too.
Well, you see, all these political parties, they have internal crisis.
Okay.
Peter Obi joined Labour Party when they are in crisis of leadership. But it was Aburi, the faction of Aburi, that brought Peter Obi to the party.
Okay.
You understand? And being that Peter Obi, a popular person, they allow Peter, in fact, they have even done their Congress, voted for the leadership of the party, and voted in the presidential election. They did that Congress. You understand? So when Peter Obi cannot contest in PDP, he now jumped to
Labour Party.
The candidate of Labour Party, a presidential candidate of Labour Party, withdrew for Peter Obi to step in.
Okay.
You understand? And Aburi and others, Labour Party since inception, they are always faction. They don't have internal mechanism of solving their own problems.
Do you think that was part of the major issues they had?
It is one, yes.
With clinching the
yes, I'll tell you yes, because Senator Adam Oshomole, he was a Labour Party. He wanted to contest under the Labour Party. This internal wrangling and functionalization of the party, a lack of internal mechanism of resolving issues and problems, that's what made Adam Oshomole to defect to Action Congress and contest under Action Congress, and he became a governor. You understand? So, one year, the same thing. The man that wear cowboy's cap, he held the party at ransom. You understand? They drag. Eventually, he abandoned the party and registered Zenith Labour Party. You understand? During Mimiko
in Ondo State.
You understand? Mimiko of Ondo State. The same thing happened. The same internal problem, the way they're fighting themselves now, that's how they fought themselves then, and the man left the party.
We cannot totally rule out the fact that every party has their own issue.
But Mercy, even APC has their own problem. But the issue is they have internal mechanism even to subside or to load down or to water their own problem.
Okay.
Even PDP has their own. They know how to water it, but the other parties don't know how to water their own issues.
And this is a major problem for them.
Is the main problem.
Okay.
But I think Peter Obi, now I think he has spent 100 days in the party, right? So
over 100 days.
Yeah, so I think they will tell us the progress they made in 100 days.
All right, thank you so much, Honorable, and thank you very much, Barrister. It's been an insightful one with you today. Of course, we've analyzed most of the major events, even though we laid more emphasis on the presidential election tribunal. I would have loved for us to go into economy and see what is happening for President Tinubu's 100 days. But before my producer cuts me off here, I liked us to round up ASAP. Thank you so much for joining us on the program. Thank you, Honorable. Of course, it's been a nice one with you. All right, our viewers at home, thank you for joining us on the Polity this week and today. It's been an insightful and powerful one with you guys, of course, watching us, and thank you for staying tuned always. Hope you've learned one or two. Of course, we are not the law, we are just citizens, but then we still have to be law-abiding citizens all through the week and of course the weekend. I remain Mercy Babati. This is where we draw the curtains for the Polity for today. See you same time, same station next week. Bye.